I will call our first case, the Gym 24/7 Fitness versus State of Michigan. This is a 15-minute mini oral argument on the application. Both sides have 15 minutes. You may reserve time for rebuttal, but we ask that you keep track of that time if we don't use it all up. And you may begin when you're ready.
All right, thank you very much. May it please the court, my name is Philip Ellison and I represent the appellants here in this Gym 24/7 case. I think the simplest place to start is what this case is not about. This case does not challenge or question the government's authority to take property or to otherwise react to an emergency. A prudent exercise of police power has been, for purposes of this case, fully acknowledged in the complaint. And on this, everyone on this side agrees. But this is a takings case. When the government takes private property and presses it into public service for a public purpose, the U.S. Supreme Court, for example, in Cedar Point Nursery, this court in Raffaelli, even our Court of Appeals in Chelsea Investments have all confirmed what has been called a simple rule. The government must pay for what it takes. Here, to combat COVID-19, the state took the facilities of gyms and fitness center businesses across Michigan for what ended up, after we filed the case, being 6 months in time. The posture of this case is important. This case comes to this court at the pre-answer, pre-discovery stage of litigation. All that's happened so far is a complaint has been filed. And at this posture, the question that was seeking to be answered by the Court of Claims is not whether the gyms and fitness centers win, but rather has enough been pled to warrant an answer from the state. Sufficient allegations have been pled to commence this case. At the Court of Claims, the state made two, and only two arguments. The first, they argued that the exercise of police powers means that no takings legally occurred. The U.S. Supreme Court in Loretto rejected that argument, as we briefed. The second argument is that the takings claims was merely temporary and thus just compensation is not required. Again, the U.S. Supreme Court in First English rejected that argument and reaffirmed that holding recently in Cedar Point Nursery. The Court of Claims merely dismissed this case without prejudice to allow the case to start.
Counsel, good morning and Happy New Year. Just a few quick questions for you on this. When you're running a fitness center, isn't the hardest thing about running a fitness center having to keep people as members? So if you close for, let's say, 6 months, you have to kind of reorganize and have to almost go back and try to get those folks who had left to come back. So when you look at this situation, it's not just that you lost 6 months. It's not just that you were closed for 6 months. It's not that the members couldn't use it for 6 months. But in your industry, it's almost like with a union, you have to reorganize. You have to now go out and get all of those people who perhaps went to other places, stopped going to the gym, to now re-sign up. So it's almost like you've lost your business and you have to start from the beginning to get those members to come back. Isn't that kind of a huge part of the fitness industry?
I would agree with you. We do not have New Year's Day resolutions every day of the week and every day of the month for New Year's or for gyms and fitness centers. So we would agree. In addition, many of the key behind a gym and fitness center is that you're renting out and utilizing the equipment and facilities that are being provided to folks who want to be able to tone and make themselves more fit for the process. It's not something that can simply be transferred into some other type of business in some other way.
And what else could you do with this property? You know, in other situations, you know, arguments have been made that, oh, well, you can use the property for other things, but it seems to me that a fitness center has kind of some real specific uses, and the ultimate notion that it's not like this property can be converted. I don't go to the gym to do other things. I would go to the gym for specific reasons. Isn't that correct?
We would agree. And what we would ask this court to consider is that when you're looking at the nature of the interest that's being taken in this respect, that you look to what the core business of that activity is, in this case being a business activity there, not just what could ever possibly be. And kind of trying to come up with an analogy that would simply highlight this difference would be as if for my brother counsel, who's going to be coming to you next in the restaurant business, to say, well, you know, the state could come back and say, well, you know, you're in the food business, you run a restaurant, well, you can write a food blog from the facility once it's shut down. Those are not the same thing, even though they both involve food. These are, from our standpoint, the shutdown of the gyms, of the actual physical gym facilities themselves, effectively killed the business for 6 total months. And as Justice Bernstein, as you point out, there's not a simple restart where people can simply pick up right where they left off.
So counsel, I don't dispute that, of course, the use is potentially very different, but taking jurisprudence disagrees with your view on that. As long as there's some use for the property, it's generally not been held to be a takings.
Well, I would respectfully disagree, and I would point you to Lucas as a guiding example of that. In Lucas, that was the North Carolina barrier island regulation that came into place. Mr. Lucas still could have used the property to camp on. He still could have used it for any number of other activities, but still the United States Supreme Court found that that is a categorical taking based on a regulation, as a regulatory taking. The mere fact that there's incidental or minor usage of the property does not preclude takings claims as a whole. That may go to ultimately the amount of the compensation that is owed. It doesn't negate the fact that the taking, in fact, occurred in the first instance.
What else could you use a gym for?
Your guess is as good as mine. At least I can't think of anything.
Some gyms offered online services, didn't they? I mean, I know that there were still some gyms that provided classes online, perhaps, membership that your membership maybe otherwise wouldn't have included it, but during COVID they did. I mean, is that sufficient, or you're saying because it's so inherently different from what was offered before?
I would say it's insufficient, but let me just clarify by saying we're representing a putative class of gyms and fitness centers, not aerobic workout studios. I mean, if in fact you were exercising to Susan,
But don't a lot of gym and fitness centers offer more than just come in and lift weights? It's a whole range of activities, right?
but those would be two separate businesses.
So are you saying that your putative class does not include anything other than in-person services?
I can speak to, as the proposed class representative with Gym 24/7, they offered simply gym services in that respect. And
so a class would be so limited?
Would be limited. We would have to meet the commonality and typicality requirements of that to be like-kind for purposes of pursuing a class, should we get the chance to make that motion back before the court.
Some gyms that maybe they don't offer aerobics classes, but they would do online coaching?
Well, I guess let me parallel this again to the restaurants, as I think is a good analogy, would be as some restaurants have, where they offer food, right? They offer food to the public. You come in, you sit down, and in the morning hours they offer cooking classes. While they're both food, they're two totally different types of businesses that are going on in the same facility at the same time. I would analogize aerobics workout and gyms as being something similar. Now, maybe the gyms in this instance are limited only to what we're actually pleading as the taking in this case. But the important part is that we're focused on those who have lost the ability to have customers come on site and be able to do their workout with the machinery and the equipment that are there. You can't send that machinery through the internet, obviously. This is that unique aspect of this particular case, and I think this is why this case is uniquely situated to be the farthest spectrum of what happened during COVID-19, because most other businesses were allowed to pivot into maybe reduced or lesser amounts of activities, whereas gyms were completely cut off and completely shut down from any operation going forward.
Counsel, I'm wondering what is the property interest here that you are asserting? I mean, I don't think membership lists are a property interest. What is the property interest here?
We would have two, and again, we have not had a chance to fully explore this, given that we are just at the first part of the court case where we're at the complaint, non-answer, non-discovery phase. That said, we would be asserting two basic property interests. One is that I would point this court to Pee Wee Cole. Pee Wee Cole says that when the government takes temporary possession of a business enterprise, the value of the damages can be the reasonable value of the property's use.
Right, and of course, in that case, they literally physically took the mine.
Well, they didn't physically take the mine. All they did was just change the title of the mine. All the same folks who were in charge, the workers, the management, all of them were the same exact people who were there the day before as the day after.
Did the government take title of the gym?
Effectively, our position is they effectively took title to the gym, because the government didn't simply come in and add regulations to how the gym operates. They shut them down. The ability to exclude is the exercise of a property right, and the exercise of a property right is what an owner does, not what a government does on behalf of property.
There was criminal, if a person were to defy this order, a gym owner were to defy this order, there would be criminal consequences, would there not? So law enforcement would basically this isn't a situation where we're asking you to please shut it down. If you were to violate this would wind up resulting in a law enforcement issue, would it not?
I would actually go one step further. My particular client, as the proposed class representative, was threatened with criminal sanctions by the Gratiot County prosecutor, and we ended up having to sue them in local court to protect them from that criminal prosecution. So the answer is very much yes.
Counsel, I'm very sympathetic to what happened to your client. Well, I'm trying to work my way through the legal questions. Right now, we're trying to decide, is it a taking, categorical, or a taking under the Penn Central factors? On the first point of categorical, you cite to Lucas, Cedar Point, First English. And I understand your argument and how they seem to be going in your direction. But then I read the Supreme Court's decision in Tahoe Sierra, which held that a temporary moratorium on all economically feasible uses does not amount to a categorical taking. So how do I work my way through the tension between these SCOTUS cases here?
So there's a couple of different approaches this court could take, and I think the simplest and the easiest one for me to argue is to say that Tahoe Sierra doesn't bind this court as to the state takings responsibility that exists.
You don't want to go there because of Hathcock.
Hathon, I'm going to be arguing.
Was it taken for a public use or for a public purpose?
Well,
if I give you that you have a taking, if you want to do it under our state constitution, it was not for a public use. It was taken for a public purpose.
Well, I would argue it was for a public use. The public use is to protect the public from being the spread of COVID-19. But I guess let me take a half step forward. That's one tranche this court could go.
You're not selling me on the state constitution. Fair enough. Stick to your Fifth Amendment.
So let me go the second tranche on this. The second tranche that this court could take is to simply deem Tahoe Sierra that type of case that where a piece of property has not yet been developed into a working business, developed into a home, developed, because it was bare land in Tahoe Sierra. The government didn't say you could never do these things or that we're taking something from you that's already there. We're simply putting a pause on your exercise of property rights going forward while they're deciding what sort of regulations to put into place.
And here did not the state put a pause on your use of this property until they could decide how to move forward?
Respectfully, no. Respectfully, what they did was here is they took the property here and said, you shall not do this because it is our reaction to COVID-19. They didn't say we're passing a regulation to say, let's stop you from building your gym until such time as we can figure out how to safely operate the gym. They took an actual operating business protected or a property or interest protected business and said, stop operating when gyms themselves are not illegal and not a nuisance in any way. And I think that's what distinguishes this case from Tahoe Sierra. Now,
so I'm going to ask you, because it's been a few days since I've read over Tahoe Sierra, is there language in that opinion that would support that? Or is this just a distinction that exists that you'd like us to hang our hat on?
I think it's a distinction from the latter because Tahoe Sierra, now this is my personal viewpoint, Tahoe Sierra I think was wrongly decided. I mean, I think it follows,
You're in the wrong court for that one.
I understand, and of course, I have not ever had the opportunity, or nor my colleagues have had the opportunity to challenge that, but I think the more important part is subsequent cases to that, such as Cedar Point Nursery, particularly Cedar Point Nursery. If, in fact, the Tahoe Sierra stands for the proposition that your hypothetical has presented to it, Cedar Point Nursery should have come out the other way. And so I would argue that, at minimum, this court should limit it to its facts, the unique circumstances, because, again, takings case, if we look through one common theme across all the takings cases, is every court says we have to look at takings on a fact-by-fact, case-by-case basis. Because there's defined distinctions.
You have a little over a minute left.
Thank you.
You did answer my question.
Let me jump in, because you just touched on a point that I'm interested in, which is the factual, intensive nature of the Penn Central inquiry. The Court of Appeals devoted, I think, one paragraph to dispensing with your Penn Central claim. You've already indicated that you haven't been able to do any discovery on that claim, and courts have indicated that these are the types of claims that parties should ordinarily be entitled to conduct discovery on. What type of discovery does your client need to undertake?
Well, I think while the trial judge in this case misframed, and the Court of Appeals agreed that misframed the actual analysis, but the underlying question is there. going to what the intensity of we know what the intensity of the regulation was because we suffered it. And we also know what our investment-backed expectations are. It goes to the third prong, the nature of the government action itself. We need to understand, why did the government actually treat gyms so drastically different than anyone else? They are the only ones that had, if I may finish.
Yes.
Does that go to the proportionality issue that I think both sides agree needs to be addressed in a case like this, whether your client was unfairly singled out and burden was placed on gyms that should have been borne by the public as a whole?
I think I would ask this court, I would take the cue from my brother counsel from the next case in his supplemental briefing to say it's not proportionality, it's magnitude, which is a different test, because the proportionality aspect is the state trying to compare gyms to restaurants to everyone else, law firms, for example. Magnitude is as to how it affected the actual property owner itself, and it would go to that aspect. And the magnitude that's there, we know what the magnitude is for what harm it caused. The question would be, what was the government's purpose? What was its interest under the third prong of Penn Central for doing what it did? Because if it was disproportionate and unnecessary in that respect, I think that heightens the opportunity for the court to conclude there was in fact a taking when balancing those three factors under Penn Central.
I guess lastly, and I know you're out of time, but I'll ask the other side the same question, but do you have any comments on the proper balancing of the Penn Central factors?
Well, I think I'm prepared to say at this point right now, and again, framing...
The Court of Appeals seemed to say, well, the first two factors weigh in favor of the gym, but the third one, this COVID was a big deal, so you lose. Is that the proper weighing of the factors?
I would say two things in response to that. First of all, the first two weighed in our factors, but they negated those by saying, well, this was temporary, and therefore it's not type of taking, which we would, as we've outlined to you, that temporariness does not preclude takings liability in any sense. That's been reestablished just as recently as Cedar Point Nursery from the U.S. Supreme Court. It's the third prong of this aspect that I think the Court of Appeals substituted its legal judgment for the factual judgment. And what happens in this respect is that because Penn Central is always an ad hoc, factually intense inquiry, it simply couldn't make that decision because, frankly, nothing was in the record from the government, and the only thing that was really in the government, or excuse me, that was in the record to establish what the scope of the government's activities were they in fact necessary, was our Oslo study. And the Oslo study said you didn't need to shut down gyms. You simply could have just done this as a regulation, much like restaurants or stores or barbershops or anything else in that matter. There's nothing there that separates it. And I think when balancing that against the two heavier factors that both weigh in our favor, once you correct the error with the temporariness of the regulation, I think all three factors will balance in our favor ultimately on this. But we need to be able to have that because I don't know what information, much like the trial judge did not know what information the state was basing its decision-making on when imposing such a drastic remedy against just this unique, specific group of business owners.
Thank you.
Thank you.
Good morning, Your Honors. May it please the Court, Solicitor General Ann Sherman here on behalf of the state. With me at council table is Assistant Attorney General Darren Fowler. This court has described the COVID-19 pandemic as one of the most threatening public health crises in modern times. When the state acts out of necessity to protect against a grave threat to public health, it's not a taking, and it removes these inquiries from the takings analysis. It's not surprising that nearly every court nationwide has rejected the novel theory of a taking in the context of COVID-19. Michigan's departure from this wisdom would make it a national outlier. Both federal and state law recognize that when a citizen acquires property, a title to property, that includes an implied limitation when the state acts in the face of emergency. We see this in cases of prevention of fire, We see it in cases of shutting down a mine for 3 years for the war effort, in the destruction of diseased trees that are affecting other trees. And right here at home, we see it in prohibition on the unvaccinated being allowed to enter public schools during a smallpox outbreak. If the court reaches the taking analysis, Penn Central is the test. The two bright line tests here are simply not applicable. The gym didn't lose its complete bundle of rights either by physical invasion or by a permanent 100% deprivation of any economic use. Under Penn Central's flexible ad hoc test, the state would prevail, and no amount of factual development would change that outcome as a matter of law.
Is the fact that there was an emergency, is that an exception to the compensation requirement? In other words, put aside for the moment, I think there's lots of reasons to question the government's response to COVID, but let's say that everything was done perfectly and it was an excellent public policy response. If it singled out your opposing counsel's client unfairly, why wouldn't the government have to compensate that property or business owner?
The answer to that question is it does take it out of the just compensation realm. It takes it out of takings analysis completely, and courts have recognized that. Both Penn Central and Lucas said that where the state has reasonably concluded that health, safety, and welfare would be promoted, there's no need for compensation. This court in Raffaelli...
Most state regulations are based on the fact that they promote the health, safety, or welfare of the public. So you mean all regulations are taken out of the takings analysis? All state laws are just, all of it's gone?
Well, when you look at
what do you all do that's not based on those justifications?
Well, when you look at the exercise of police power, there could be questions in terms of cases on the margins. But when you look at the doctrine of necessity, we're talking about here an emergency, a pandemic that this court
what
has...
if the government said it was an emergency, but it wasn't? Or maybe it was initially, but then it stopped, but then the regulations continued for years and years and years. Does the government just get to show up and say it was an emergency and therefore you're out of luck?
In the landscape of the legal puzzle and the remedies that are available, that would not sound in taking. That's going to sound in due process. And yes, there may be a remedy if that's the question, but legal tells us we're not looking, when we look at questions like that about efficacy and the reasonableness, we're looking at due process. We're not looking at the landscape of takings.
Counsel, first off, good morning, Happy New Year.
Good morning,
And it's
Justice.
always lovely to have you in our court, so
Thank you.
welcome. But I want to just kind of go to the argument that the government's making that really kind of catches my attention the most. And the government's basically saying that, well, there's other uses that you can have at a gym, that they weren't completely deprived. So the fact that they weren't completely deprived doesn't make it a taking. I just find that to be a really problematic, disingenuous argument, and I'd like you to comment on it, because there's certain things, as Brother Counsel has elicited, that are very unique to what goes on at a gym, right? Like when I go to the gym, I'm going because I want to use the treadmill. I'm not going to the gym for any other purpose than to use the treadmill or to use the Stairmaster. So there's a very unique, specific element that goes into going to a gym than in any other place. And also, I'm just going to ask you a follow-up question, which is, why wasn't there a workaround? If the government basically could create a workaround for restaurants, they could create a workaround for dentist's office, where basically I can't imagine anything more intense than the dentist's office. Why was it that there was not a workaround as it pertains to gyms? And if there wasn't, shouldn't we basically take that into account? That the government singled out gyms, and the question is why? And what should the court's response be to that?
Well,
Especially when there's a specific use that people have to go to a gym. I realize I asked you two kind of intricate questions there, but I've known you for a long time, so I know you can take it.
I'll take both those questions
Great.
and answer
Thank
them
you,
in
Sharon.
turn. I'll answer first the question about the use of the land. Sometimes takings jurisprudence can seem very harsh, but many cases, the U.S. Supreme Court cases, have said that, you know, if even where temporarily, which is the case here, temporarily we are
taking away, and sometimes even permanently, the most valuable use of the land. That has still not been found to be a taking. If you look at the Andrus versus Allard feather case, they took away the ability to sell feathers, which was the most viable economic use, but the court said when you look at that bundle of rights, the owners of those feathers still could possess, they could devise, they could transport. And when you look at takings analysis, you look at that entire bundle. If you look at the Goldblatt case, that was the case that prohibited excavation below the water table. That was, for the sand and gravel company, the most beneficial use of that property. But there was no showing that they said, well, you still have the value of the land. There were other uses that were permitted. Maybe they were difficult uses, but the court said as long as the opportunity exists, that was not a taking. So we look at a lot of situations and cases where the use of the
counsel,
land.
I'm sorry, but brother counsel made this very specific argument. He said that ultimately, we're not here talking about fitness centers that provide aerobics or classes. We are here to talk about gyms that specifically focus on equipment and the use of equipment. So if you're not going to be able to use the equipment or to benefit from the equipment, what other use of that property is there?
Well, I'm going to draw, I will answer that and then I will go to your second question, but I want to draw
And I'm asking you a lot.
I will draw brothers to counsel's attention to the class allegations in this case, which were gymnasiums, fitness centers, recreation centers, sports facilities, exercise studios, and like-kind businesses. So the class that they want to certify here is pretty broad. It is not just gyms with equipments. It's all kinds of fitness-type facilities. And answering your second question, Your Honor, you said, well, why isn't there a workaround? Well, the state, when it was attempting to protect in the face of this emergency, tried its best to find workarounds where it was possible, given the nature of the business, and there were workarounds. The restriction on the use of these gyms was still left a lot in the bundle. The owners could go into the gym, they could divide, they could sell property, they could deep clean, they could have their employees go in, and the other workaround that was offered there was they were permitted to use it for other purposes that were in line with the EOs. For example, as Justice Kavanaugh mentioned, some online fitness classes, or selling product that was consistent with the EOs. So there were workarounds that were attempted, and any difference between this and the treatment of other places of accommodation has to do with the nature, what the state thought was the nature of these kinds of like fitness activity, where it's difficult to wear a mask or keep a mask on. There's a lot of high contact, there are shared surfaces, and that all went into play with how the burden was allocated. But I want to say here, it's so important that the touchstone here is not just the burden on a particular type of business, but the allocation of the burden. And here, that allocation was not disproportionate, which is really important to, if a court reaches the Penn Central analysis.
But isn't that a factual assertion you're making? And shouldn't that be subject to discovery and be tested in the litigation process? Or the government just gets to declare that and we all have to accept it as uncontrovertible fact?
Well, the gym here has conceded that there's a proper purpose and that it hasn't challenged the reason the government did it. And takings analysis.
But they seem to be challenging the extent of the regulation, do they not?
Everything we need to know about the extent of the regulation on similarly situated businesses is encompassed within the executive orders. What we know from those orders is that they treated.
So the executive orders themselves establish facts?
Well, yes. I mean, every preamble to the executive order established what the necessity was, what had been happening, during the time period.
The governor's assertions there are unassailably true? That's remarkable in today's era. Any politician makes an assertion, Donald Trump says something, or Joe Biden, and the courts just have to accept it unquestionably? Is that how it works?
No, but for takings analysis, for purposes of trying to figure out if we're in Penn Central territory and we're trying to figure out those factors, everything that there is needed to know about the burden and the way it's allocated.
What would happen in this case if there was discovery into some of these things? Why would that be so detrimental to the state? If you're so confident in the state's position, why not, what would discover, I don't understand. Wouldn't the state want to have an opportunity to defend its actions?
Well, from a legal perspective, we don't have to allow discovery if discovery wouldn't change the outcome. And here, if you look at the contours, the purpose and design of the EOs, they answer the questions that need to be answered for takings jurisprudence.
As I sit here, I don't know whether the discovery changes the outcome. The question is, doesn't there need to be discovery so that the process can work itself out and so that the trial court can make an informed decision under Penn Central, which is a fact-intensive inquiry? So I mean, I don't know how we can sit here and say whether it changes the outcome when we don't know what facts are going to come out in discovery.
The takings analysis doesn't need to look, when there's a widespread regulation, the takings analysis doesn't need to look at the economic impact on every individual businesses. And here we would be looking at thousands of businesses. And in other cases involving places of accommodation, we would be looking at tens of thousands of businesses. Is it your side?
Didn't you argue proportionality? We have to decide whether this business owner was unfairly singled out. Isn't that your client's position?
We're looking at whether the gym was singled out from other similarly situated businesses, and it was not. That allocation was...
But that's an argument to the trial court to limit the scope of discovery. That's not an argument to make here, is it?
I disagree, because the executive orders on their face show that the impact was to a particular... We know what the impact was. It was a particular strand in the bundle of rights, and that was the a cessation of the temporary use, and not for all uses, but just for one kind of use, which is public access. We know that for the impact. For proportionality, we know that because they applied that same burden to all fitness-type centers. And in fact, they also applied a significant burden to all places of accommodation. So we have that factor. We also know from the EOs what the reciprocity of advantage...
Aren't you just saying that this is a legal question, not a factual question? Isn't that at bottom what your argument is to us? If all we need to do is look at the regulation itself, and there needs to be no discovery, then you're saying if the government claims an emergency, I suppose, there's no way to contest that, and it's simply a legal question at that point. Based on the regulation itself, and if the governor does a nice job on the introductory, the preamble, then it's over.
If the question about how the governor did what she did, the reasonableness of it was at issue, that would be a due process question. And I think that would lend itself to factual development. But the takings analysis is different. The takings analysis talks about, at a higher level, the burden and the allocation and the reciprocity of advantage. And we know here, and this goes to one of the questions that was asked earlier, we know here that one of the things that the gyms benefited from was the ability to get people back into their gyms, to have people be healthy and safe and back in the gyms. And while Justice Bernstein, you mentioned maybe there's a rebuilding of the clientele, but you can have no clientele if those clientele are sick or they are too afraid to go back in to any public building, and especially to a fitness center.
Counsel,
and so there was...
No, I have a question for you, and I think you're doing an outstanding job as always, but here's the question I just kind of want to go back to is, and I like to, my jurisprudential philosophy is keep things simple as much as possible. So looking at this from the era of simplicity, the question I have is basically, is it really the government's argument that, just to keep it simple, it's the government's argument that, hey, we can take your property, we can do it by force, we can, in this situation, of course, you weren't taking the property, but we can use it, and I hate to say it, at the barrel of a gun, because if you basically attempt to defy this, you're going to have the police at your door. So we can go, we can do this. And a gym, which is basically a highly specific usage, right? Every other entity, you can probably find other ways to do things. But in this situation, I think we have to say that this is a very, very intricate, highly usage place, right? People are going there for a very specific purpose, right? And I guess at the end of the day, it was a 6-month period. So is it the government's argument, just to sum up this whole case, that the government can come in and basically say, okay, you know what, even if there's a highly specific use for this property, we are going to basically shut you down, you're not going to get compensated, we're going to have the power to do this, and as long as you can find some simple thing that you can do, that should be enough. And in this situation, your argument is that, well, you could sell products. I mean, selling products is not something that's going to keep a gym owner basically feeding his family. That's my question. Keeping it simple. Specific use of the property, highly specific, use taking it away by force, not depriving people of the ability to use it, and then basically this notion that, okay, well, we're the government, we can come in and do this, and if you can find some little usage for this, that should be okay, which could then be used by any other business owner, that if you're going to say that I can go to the gym and buy items, or they can sell me items over the internet, then that should suffice. Isn't that a concern for business owners all across our state?
Well, I don't think I have to say it, because this court said in Raffaele that even vested property rights, the property owner necessarily has to expect that uses would be restricted from time to time when the state exercises its police power. And this is not on the margins of the exercise of the state's police power. This is at the heart of the state's police power. And I also think it's important to keep in mind here, as much as everybody understands that many places of accommodation suffered an impact, it's important to remember that this was a temporary cessation of one strand of the use of that property. When you look at the bundle of rights of a property, it isn't just in the lost profits. In fact, the court has said that is not part of the takings analysis, or it's a very small strand. Andrus versus Allard, the U.S. Supreme Court said that is profit making is a very small strand in the bundle of sticks that the property holder owns. Thank you.
Wait, I got one.
She'll be back for the next case, too.
All right, go.
Well, wait.
No, we'll go. I'll get you next one.
Pardon me? One. Oh, okay. Thank you, Ms. Sherman. You can be seated.
Thank you, Your Honors.
Mr. Ellison, we have one question for you. A quick rebuttal.
I'm going to make it a compound question.
Nice long question. Let's go, right? Okay.
I
Go
took
ahead.
up your minute of rebuttal, so I feel a little guilty. And I think you're done. You're not on the next case. So just briefly, response to, is the only claim your client can make here a due process claim, number one? Have you made such a claim, or will you, I guess? I'm curious. But since the state seems to think that's the only type of claim that can be presented here. And second, to the notion that your client doesn't need discovery because all the facts we need in this case are set forth in the preamble to the executive orders. Your response to those points?
Well, I'm going to take the second one first. We would obviously disagree with that. Many of the, and again, I would ask this court to review this case through the lens of the posture of where this case is. This case is at an answer and a pre-answer motion for summary disposition. We included as part of our response the Oslo study that says the governor shutting down these gyms was in excess of than what needed to be done. And I think you hinted in today's modern jurisprudence, we don't accept the decree of the king unquestioned. And I'm being a little facetious on that, but what we do is, as part of our jurisprudence is that our political and governmental leaders can be questioned in a court as to what they're doing and their reasonings for why they did what they did. Now, again, I go back to my introduction. The question is not today, is not whether we win the case. The question is, has enough been pled as a takings? And what we're hearing today is all sorts of arguments that were never raised before the court of claims in that pre-answer motion for summary disposition. Now, to get to your first question, and I would reference, if the court needs to go back, in my introduction was talking about that the two arguments made were temporariness and that we have police powers that precludes takings claims altogether. Nothing more was asserted, not necessity, not this balancing. They didn't try to argue the balancing of this. This was all done sua sponte by the Michigan Court of Appeals in excess of the factually intensive ad hoc inquiry. And I have to plead ignorance. I don't remember your first question now with that.
Curious about, have you asserted a due process claim?
We did not assert a due process claim because a group, a gym ownership, or excuse me, I should say a gym advocacy group called LIFT had tried doing that in federal court, a due process case, and was unsuccessful. And so what we didn't want to do was run up against that as well. The reason why we picked takings cases specifically is because the government took the position over and over and over again that we're doing what we're doing for the public purpose of protecting the public from potential COVID-19. And if there's a public purpose and the government takes property, which we acknowledge, and we have said over and over at every stage of this litigation, the government can take. But if they're going to take, they have to pay, because you don't want some people to bear the burdens that benefits the public, that the cost of such is placed upon a small, discrete set of individuals. And there's a line I use from the New York courts that says the accident of ownership should not be the basis on which the cost of society, that the cost that society benefits should be bore upon those specific individuals. Ownership itself should not be the basis for who has to carry that burden forward. It's the public as a whole. If we need it, we need it. But make sure that the public, if they benefit from it, should have to collectively pay for it. Thank you very much.
Thank you both. The case will be submitted.